As a parent advocate, I know that families need a lot of information in order to navigate the special education system. This series of advocacy shorts is a collaborative project between ASSA, the State Association of Private Special Ed Schools in New Jersey, and the attorneys at Hinkle, Finkles, and Pryor, who generously donated their time and expertise to help answer some of the more common questions that families have as they try to advocate for their sons or daughters in the special education system. I hope you find them helpful. Paul, I'm hearing from a lot of parents whose local school districts is trying to pull their kids back from special education placements that are working really, really well. And parents are scared. What can parents do if a district wants to change a child's placement or change their child's services and the parent disagrees?
It's interesting you mentioned that, Brenda, because we're seeing the exact same thing. It appears that school districts are more aggressively than ever before attempting to pull students out of private out-of-district placements and returning them into programs, or attempting to return them to programs that may not be able to appropriately serve the student. So parents need to be aware that when that happens, they need to move very quickly. And they have in their toolbox a very important and powerful tool commonly referred to as stay put. It is a legal principle which stands for the proposition that if a district decides to change or alter a service or placement that a student is currently receiving, if they act quickly enough, that they can keep the program in place during the pendency of a mediation or due process hearing. And the time frame that parents have to act within is within 15 days of receipt of written notice of a district's intent to change a placement. So it's not a time where they can really, dilly-dally or contemplate what their next move may be. They need to file for mediation and or request a due process hearing within that 15-day time frame. And if they do that, the program will stay in place, or the service will stay in place while a hearing or mediation is conducted.
So if a parent gets a letter or notice or goes to an IEP meeting and it shows that the child's placement for the next school year, for example, is changed from one program to another, they just need to write a letter?
That's pretty much the size of it, but they need to make sure that they send that letter into the Department of Education. They need to follow the procedures that are outlined in the back of the manual that they receive from their school district. They need to avail themselves of the dispute resolution system. It doesn't have to be fancy. It doesn't have to be very detailed. It just can simply indicate that they disagree with the district's determination and that they want either a mediator to help them resolve the situation, or they'd like to have a hearing in front of an administrative law judge in New Jersey or a hearing officer in the state of Pennsylvania.
Can a district tell a parent that they're going to bring a child back into an in-district program that doesn't even exist yet?
They cannot. Oftentimes districts attempt to do that. Parents have the opportunity to obviously review that program, ask very critical questions about the quality of that program, about what's going to take place in that program, but really it's the child's IEP that governs. So the IEP team will have to articulate through the IEP what specifically will be provided, what levels of supports will be given to the student, how many hours of related services, if that's an issue, will be provided, and all of the regular content of an IEP must be in place. It is not simply enough for a district to simply say, we're no longer contracting with a particular school and we've established a brand new program within the district and we're bringing all of our students back home, which is commonly the way it's characterized.
I've heard districts tell parents that they just can't afford to keep kids in out-of-district programs anymore. Is that a legitimate reason to bring kids back into in-district programs or to change placement?
No, it is not. And in fact, it's an illegal reason to bring students back into an in-district program. Monetary considerations can never be a basis for providing any level of services to a student with special needs. And to say otherwise is illegal.
How long can this stay put provision keep someone's son or daughter in the program that's working for them?
It's a good question. It basically allows the student to stay in his or her program through the pendency of a dispute. There are very tight and prescribed timelines which these disputes must be resolved within, but they don't always work out that way. And so this is a mechanism that allows the student to continue to receive the services that he or she is accustomed to, while the parents and the educators either negotiate an amicable resolution or battle it out in court. The theory being we don't want to visit harm upon the student if the parent ultimately prevails and the student has to return, or should return, back to the program that the district originally placed the student in.
You mentioned something about written notice. What would that look like? How would a parent know that they got written notice?
Well, a common form and the most concrete form is an IEP that's delivered to the parent, which changes the student's placement. But it can be a letter from the student's case manager or other district official, which notifies the family that the district intends to change the student's placement. This is also important when we have changes in services as well, and stay put applies there as well. For example, if a student is receiving 3 hours a week of individualized speech therapy and the district wants to cut it once a week to group speech therapy, parents, if they act quickly enough, can keep those related services in place as well.
You talked about a 15-day timeline for the stay put rule. Is that the same nationwide?
Ooh, that's a good point, and thank you for reminding me. That was that's the timeline in New Jersey. The stay put rule or the stay put principle does apply nationally. In other states, the time frame may be longer or shorter. For instance, in the state of Pennsylvania, you have 10 days to file a request for mediation and due process with the Office of Dispute Resolution, as opposed to New Jersey, 15 days with the Department of Education.
So parents in other states should just check their state rules and regulations?
They should check their local rules, but the overall principle is parents should act very quickly upon receipt of written notice. There's no point in waiting till the 9th day or the 10th day or the 14th day or the 15th day. You just need to move very quickly.